judgment in item 1, WPC 5223 of 22.
I am of the considered view that the petitioners are entitled to the minimum scale of pay and other allowances in terms of Model Rules 2020, as their duties, functions, and responsibilities are same with those members who were appointed as per the new Consumer Protection Act 2019 in the Model Rules 2020. Accordingly, writ petition is allowed.
Obliged, Lordship.
Lordship, may I beg to mention item number 9. This is a fixed matter that I have already mentioned it on yesterday.
No. Item 9.
Yes, item.
As per the last order, it is to be listed today only.
No, yes, as per the last order, it has to be listed today. I have taken consent with the parties and matter. Yesterday we have fixed the matter on 10.
No, in that case, matter was last order. You see the last
Yes,
order?
yes, last order.
It is to be
Matter
taken
is
up
fixed on
today only.
Yes, but it was.
We'll take it up today. What's there?
It was on today, but the party has settled it be on Monday, on 10. Monday, 10 June.
Why a special
The
day?
party are not appearing.
Huh?
Party are not appearing. That is why.
You are not appearing.
I am mentioning on behalf of other party. This Titaki. I am mentioning on behalf of Titaki, and I have taken consent from Advocate Diki Pangli.
So we'll take it after 4 weeks.
No, already matter has been fixed on 10.
It's not
Yesterday-
your fixing. The court has already fixed the matter today.
Yes, yesterday I have mentioned it, and matter has been fixed on Monday 10. Yesterday,
Why a special day for you?
party are consenting matter.
It's not your consenting. You have to see the convenience of the court also. It's not only your convenience. And court has fixed the matter today only. So that's why they listed today only.
This, yes, last order. Yesterday, matter was fixed on fixed for 10.
See, it's amount to defying because yesterday we didn't know whether the matter was fixed
Yes.
today or not. That's why we allow. But when you check up this, it is already there's an order for listing the matter today only.
Yeah.
So
I have taken.
what is the urgency?
Urgency? The Advocate Diki Pangli told me that there is urgency. He wanted to press this interim order. That is why.
Are you appearing for petition?
I am
or
not
response?
appearing. I am this on the opposition. This respondent side, Mr. Taki is appearing.
On the prayer of Mr. T. Tapak, London
Yes.
Council appearing on behalf of Mr. T. Taki,
Yes.
London Council for the respondents. List this matter after 2 weeks.
Maybe on 10.
10
Monday,
it falls
Monday.
after 2 weeks.
Because party is consenting, this Mr. Taki has to come from this Pasighat. That is what they have already scheduled. That is what. If, this
So
order-
footprints has to be given to the convenient of the lawyer.
that,
It has to be convenient of all the parties, including the
Yes.
court,
yes.
not only parties.
That is there, but this petitioner side, this Mr. Pangling has already consented to be fixed the matter on 10.
It's okay, it's maybe your concern, but court has to decide that.
That is up to this honorable court.
So we were fixing it after a week, not fixing the date. Not 10th, make it 12th.
Alright.
Yeah.
Yeah, I want to mention item number 4.
Item 4.
Yes, item number
Yes.
4. Yeah, I'm on behalf of the respondent number 5, and we are filing the reply today.
What is this? List this matter before any other appropriate bench. Huh?
My lord, there is interim, but that may continue, my lord.
I cannot take interest.
Lordship,
You may make a mention before the court number 1. All right.
Lordship, I beg to mention item number 7. I'm on behalf of the petitioner.
Yes.
Some more time is sought for filing
File
the,
reason there.
yes,
Mr.
the takap.
T,
Takap.
your name is not there.
I'm on, for the, I'm
Mr.
on,
T. Takap,
yes,
learned counsel appearing on behalf of Mr. Arsona, learned counsel for the petitioner. Press for listing the matter after 2 weeks,
3 weeks.
after 3 weeks. For filing affidavit in reply.
Yes.
Mr. Praise the Lord, list this matter after 3 weeks so as to enable the land council for the petitioner to file affidavit in reply.
Obliged.
My lord, item number 8, my lord.
8, yes,
My lord, I may be given 2 weeks time, my lord.
why?
For adjournment, my lord. My lord, government advocate had said I have not given the extra copy to him. Today I'm giving, my lord.
They have no problem.
Hmm.
Government doesn't have the problem with having no extra copies.
My lord, I may be given adjournment, my lord.
Odugong,
Yes, my lord.
Mr. Odugong, land council for the petitioner, press for listing the matter after 3 weeks. List after 3 weeks.
Mention.
Yes.
I beg to mention, my lord, item number 11, my lord. With the,
11.
with the consent of other side, my lord, may I pray this be listed after 2 weeks, my lord.
Hmm?
May be listed after 2 weeks, my lord.
On the prayer of Mr. L. Permet, land council for the petitioner, list this matter after 2 weeks.
Obliged.
Yeah, my lord. My lord, I beg to mention item number 24.
24.
Yes, my lord. My lord, there's a scope of settlement between the parties, my lord. Therefore, my lord, 2 weeks time may be given.
Is it?
Lordship,
You are for
Petitioner,
T. Sunil,
yes,
on behalf of T. Sunil.
on behalf of teams.
MS
Jiva sir,
G. Basar, learned counsel appearing on behalf of Mr. T. Sunil, learned counsel for the petitioner. And Mr.
Kiado.
K. Yadav, learned counsel for the respondent, jointly submitted that endeavor is being made to settle the matter outside district. Therefore, they have prayed for listing the matter after 4 weeks,
2 weeks, my lord.
2 weeks.
Lordship, there is another one more
Prayer.
Connector CRPC in number 46 is there,
Prayer is
which is
allowed.
supposed to be
List-
listed today.
List the matter after 2 weeks. List of the list this matter along with CRP
CRPC 46.
46 of 2023.
Yes, my lord.
Yes.
Your Lordship, I beg to mention item number 22.
20?
22.
Yes.
On behalf of Deepang,
Hmm.
Lordship, this matter may be listed after 2 weeks.
On the prayer of K. Yadav, then counsel appearing for Mr. Deepang, learned counsel for the appellant, list this matter after 2 weeks.
2 weeks.
Your Honor, I beg to mention item number 20 and 21.
Why?
The senior counsel is currently out of station
Why is he out of his station?
for the counting of votes, Your Honor.
Has he contested?
No, he has not contested, but he is very, very much interested in the results.
Not contested, but interested.
Very interested, sir. Your Honor.
It's 2019 matter. Man is in jail or he's out of jail.
I'm not aware of the facts, Your Honor, sir. This is
On the prayer of Mr.
Mukbang Curtain.
Huh?
Mukbang Curtain.
M. Pratin, that is
Yes.
council. Good there. Appellant.
Thank
Come on, list this matter after.
After, as per your convenience, Your Honor.
After?
As per your convenience, the court's convenience.
After 3 weeks.
Okay, thank you.
No problem, because petitioner was already expired
Expired.
last year. And they supposed to file a substitute.
Petitioner.
Yes, petitioner.
It's a
Revision
criminal-
petition. Revision petition
Okay, criminal appeal, it's,
filed by JK.
no, criminal, item 20.
No.
20 and 21 both, Your Honor.
because
Then in that case, item 20. Huh? In item 20. But in item 21,
Yes.
same, press person.
Much obliged.
Mr. M. But Leonard, counsel appearing for the respondent, submits that the petitioner has expired, for which the learned counsel for the petitioner has to file a substitute application for substitution. You file it.
Yes, Your Honor.
It's a criminal revision petition. It's not the accused.
No,
has died?
he is the complainant in
Okay.
the lower court. She is the complainant in the. And
Otherwise-
husband is the accused.
Had it been accused, it
Uh,
gets abated.
Yes,
But
actually
it's
what
not
happened,
it's not the,
this is a complaint case
yes.
and the.
No, had it been then accused, in the case of, on the death of accused,
No,
gets abated.
she is the complainant.
Okay.
Yes.
You file a application for
Yes,
substitution,
Your Honor.
if you want to continue.
Many times they have taken the.
Yes. It's 2019 matter.
Yeah.
The last times,
Yes, Your Honor.
you file an, if you want to continue, you may not like to continue also. Is not it?
Hold on.
The respondent was acquitted.
Yes, by the appellate court,
Hmm.
he was, initially it was original court, he was convicted, then filed an appeal before the district and session judge. And session judge.
It's like a instruction.
So they come at
If she,
the.
if the complainant,
We waited
Has
for
that-
client's instruction, Your Honor.
you find out. The legal heirs may not like to continue also, if it's case of acquittal.
Much obliged.
Lordship, I would like to mention one unlisted anticipated bail application that may be taken in last September.
Why?
It's a little bit urgency. And Lordship, I would like to mention item number 12 that may be fixed after 1 week. Lordship. I am the petitioner for that case.
It's in order stage.
Yes.
I mean,
who-
it's listed in order column. We'll see what is there, what is to be done.
all right.
If I may, Your Lordship,
Yes,
I would like to mention item number 17.
17.
Yes, as the senior counsel is out of station due
We'll see, you be there. Item 17.
to 17, yes.
It is listed for orders. We'll see. If you, have you gone through the brief?
No, sir.
You check out from the court file.
The
what is to
leading
be
counsel
done.
is out of station due to
Doesn't matter.
medical
We-
emergency, sir.
That's why, that's the reason I want you to go through the file. Again, and give him, go through the file.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 6. On behalf of the Kamduk, standing counsel.
Item number
6 here.
6.
Yes. Matter may be adjourned for today as he is having some personal difficulties. On behalf of the Kamduk.
Have you taken consent
Yes,
from the petitioner? Item 6,
6.
Mr.
M. Ratan.
M. Ratan, learned counsel for the learned counsel appearing on behalf of Mr. D. Kamduk, learned counsel for the respondents. With the consent of the learned counsel for the petitioner, request for listing the matter after 4 weeks. Praise the Lord,
Deeply
list after 4 weeks. Yes,
So Your Lordship, may I mention item number 23?
20,
23.
23.
The council is not in station, so may it be taken up after 3 weeks.
Well, all these cases are listed for mention. If it's to be mentioned, why it should be listed? Call the in charge. Who's the in charge? Hmm? Will direct the registry not to list the cases. On the prayer of Miss MS, Learned Counsel appearing on behalf of Mr. Sunil Mo, S. Mo, Learned Counsel to the President. List this matter after 4 weeks. 4 weeks.
3 weeks.
4 weeks. 2 weeks or 4 weeks?
3 weeks.
3 weeks. Why the applicant is not the party here? It is the accused.
Accused.
Why don't you make him an applicant who has shown the affidavit?
Okay.
There's something mistake, is it not?
Yes, sir.
You are filing this application on being authorized by the accused.
Accused, yes.
So he should be a party here. He should be a party here. Make that.
Now then,
You file it today, we'll take it up tomorrow.
by
Because normally the applicant should be the person who is authorized, who has been authorized. Authorized person should be a applicant.
Yes, sir.
You have not made him an applicant.
yes, I have not. So my
Mr. K. Tariq, Land Counsel for the petitioner. Press for withdrawal of this petition, withdrawal of this bill application.
my
The liberty to file fresh.
because applicants, he is from the zero. So you went back yesterday. So I mean, to change on the course title.
Not here, not here, not here. Chamber. No, there's no serious thing, but they would like to ask us.
I may be allowed to change the course title only, because my lord, he has to come again.
No, that will be a problem because it will not be tally with the other petition.
It will tell you, my lord.
Hmm?
It will tell you.
Page number will be different. All right. In second, page 2,
Phase two.
second this thing, where should have been the name of the applicant here.
Yes,
Instead of
that's,
Taro Polo.
one,
You correct it by filing this thing. Amended cost
again,
item.
again, for that's, this particular person is to be swear, I think. That's applicant.
Will allow you to swear the affidavit.
I am able to.
No, because nowadays, it's CIS doesn't support. Why?
Then,
Withdraw it, file and press.
difficulty is that she has to come again from the zero applicant.
No, I'll allow you to file the affidavit by as a counsel,
As a counsel.
because only name has to be changed. Page 2, you change this name only.
Tarupulo.
Instead of Tarupulo, who is this?
His sister.
Instead of you, instead of AP versus first, this will remain.
Yes.
Second one, page 2. See Tarupulo, so and so, so and so. This has to be changed.
And
It should be replaced by the
Taro Yadi, this sister.
Taroyade.
Hmm?
Replaced by the Taroyade.
Am I correct?
Yes. Yes, yes. So I thought
We'll take it up tomorrow. You do whatever you want to do.
it should, if this court pass some order, observation, then I'll do that. Otherwise, registry will again.
Mr. K. Tariq, Learned Counsel So the applicant is permitted to file an amended post title replacing the name of the accused in at second para of the post title at page 2. List but the day after tomorrow. Tomorrow, day after.
Tomorrow, no, day after tomorrow.
Day after tomorrow.
License.
Yes, my lord.
What is the stage of trial?
Yes, I have next in evidence stage, Your Honor. The next are D, Your Honor. I have
Pending before where?
JMFC Coloria.
Colorian.
Yes, Your
Heard
Honor.
Mr.
P. Bate.
Lordship,
But
may I lordship? Here, lordship, here also lordship. They have not, separately, they have filed the affidavit. They have the authority letter, lordship. Last occasion, the honorable court had made observation that if they have
Okay.
come in.
So you have to file the affidavit. It has to be accompanied by affidavit of each petitioner. How many petitioners?
Lord, there is 5 petitioner, Your Honor.
So you will have to be only the
Lordship, I have submitted the authority letter.
no. No. This is the procedure, elementary procedure. You take the affidavit of other persons. They have been authorized the petition number 1.
Yes.
So you file another 4 affidavits on behalf of petition number 2, 3, 4, and 5. Only affidavit. You file it. Mr. T. Pate.
Yes, P. Bate.
Bate.
Yes.
Then the concept of the petition is permitted to press that he may be allowed to file an affidavit on behalf of petitioner number 2, 3, 4, and 5. Praise the Lord. The concept to file affidavits on behalf of affidavits in respect of petition number 2, 3, 4, and 5. List after a week.
No, Lordship,
After a week.
after 3 weeks.
Why?
Since I have matter in JMFC Coloria.
Okay. After 3 weeks.
Yes.
License.
Lordship, the matter may be adjourned, Lordship, as I am going to file one IA tomorrow, Lordship, as I have received the copy today itself, but I could not file today, Lordship. The matter may be taken up with along with IA on next Tuesday, Lordship.
You have already retired.
Lordship.
Have you retired?
No, Lordship.
You are still in service.
Lordship, that is.
Are you still in service?
On that case, Lordship, I have to take instruction. I have no idea.
What is the matter? What is the matter?
Lordship, I have not gone through the brief.
You go through
today.
then we'll take it up. Give me a second copy.
May please, Your Lordship.
Yes.
I think the respondent side again remain absent, and last order was very clear that in case of absent, court will take.
Yes.
Now was this, appeal, second appeal, there can be admit, then issue notice by granting the substantial.
Where is the, have you given the draft,
Pardon?
draft,
Yes,
substantial
draft
question?
issued in page
18.
18. That's why last lordship has already given time saying that if respondent remain absent, what will take so much of that case? And
These are, I don't think these are the substantial question of law.
yes.
Yes, Your Lordship.
There is a lordship, but
No, with the draft, I don't find any substantial question.
kindly see number 3. The sale deed executed only by the seller or respondent number 1, which is not registered, can be a valid document or not. Just number 1. Then even other also lordship, as per the settled law or address code, I have an authority also.
Only 3, we'll frame only 3. Rest are not substantial.
Lordship, kindly see, this is the authority. Page, sorry, that is paragraph 10, relevant is 11, Lordship.
Therefore,
In this case, so many discrepancies there. That's why I prepared a draft substantial question of law, where I have not given any notice for reselling the property. Then on presumption, the learned trial court has, on presumption, saying that being a member must have known. So all are of course take of the case. But as per this settled position of law, this also can be also a substantial question. That's why I have given a draft.
it says that it arises is of a magnitude that it gives birth to a substantial question of law.
Yes.
What evidence has not been considered?
Your Lordship, may I?
What evidence has not been considered?
Lordship, what happened? The respondent number one is the society. And every proceeding, they used to reduce into writing, whatever the meeting procedure. But in my case, not a single document they can prove that given in comply with the conditional set deed, I have been served any notice for giving opportunity to purchase.
These are all.
Then another point is that if we go through the entire judgment, then that on presumption, saying that the respondent has proved the case. Do not tell judge. That's why
No, if you are relying this, what evidence the court has, trial
Yeah.
court has refused to take
Yes,
into consideration?
yes,
Which evidence?
yes, Lordship, I saw only one. Page 132, Lordship, 132, then 11 pages, Now, page 11 page is 149, paragraph 19.
149.
Yes, 149.
Yes.
And then I will skip entire because just relevant. Come to 150 page. The suit land. It cannot be believed that the opportunity was not given to the plaintiff's husband to buy back the land.
150.
Yeah, 150.
Started-
Then come to this para. Then
Para?
actually I have skipped some 149, but come to 150 page from very beginning. That is suit land, and it cannot be believed that the opportunity was not given to the plaintiff's husband to buy back the land. The plaintiff was not ever or laid any evidence to show that the dependent society had any reason or malice against her. Moreover, the plaintiff and her husband were members of the same society, and it cannot be believed that they did not know that the society was trying to sell the suit land. More so, when the society discussed this issue in every general meeting held on so and so, so and so. That is the only presumption that being a member is, but the learned court below could not find any evidence that I have been given the opportunity by issuing notice or reflecting that in any meeting.
You were the plaintiff.
I am the plaintiff, yes. So likewise, there is so many discrepancies there. And they failed to produce single document that I was given the
So
opportunity.
according to which are this cannot be, 9 cannot be substituted. We'll consider 3. Then
Yes, 3, then 4.
Your Lordship, if I may, Your Lordship.
this way. Then six, 7.
Yes. Yes, 6, 7. I think that will suffice.
Yes.
Yes, Your Lordship, whatever my learned senior counsel has mentioned, those are not questions of law, but rather they are facts. He's questioning the facts. Moreover, Your Lordship, in this matter, the appellant was not even a party to the agreement. And she already knew that such an agreement of sale deed was made. She knew about it, and her late husband, Guru Hasang, he also knew about it. They were informed, they were intimated about such and such meeting was going on. They were
It's the legal heir.
Yes, she is the legal heir. That was already decided by the London.
but your lordship, the sale was already been done. It was already
No,
concluded.
that thing which first ground which first submission which you have made, that has been you are not challenging that
Yes,
finding.
no.
Your lordship,
You are not challenging that finding,
your lordship, yeah,
that whether he is a party to the sale deed or not.
your lordship, we are challenging that the appellant was not a party, and
No, you are
Sale
saying
deed-
that is the finding of the trial court. You have not challenged that. Have you filed an appeal
No.
against
Your
that
Lordship.
finding?
We have-
Did you file an appeal against that finding?
but we did mention it in our written statement that
Doesn't matter. After the written instrument of the trial, completion of the trial, there's findings are there. If you are aggrieved, you have to file an appeal. Any
But-
findings which you, if you are aggrieved, if you don't file it, you cannot agitate on the appeal of the other appellant.
but your lordship, someone who was a witness to an agreement, someone who
We'll hear you.
your lordship,
We'll frame it, admit, and we'll hear it. All right. Heard Mr. M, but learned.
but we have our objection, your lordship,
Where is your objection?
that she was not the party, and this
Have you filed any objection?
no, your lordship, but we are
Then you file an objection, we'll admit and we'll hear it or fix it for hearing.
yes, your lordship.
Hmm?
I will discuss that with my senior counsel, and then we will file by.
It's listed for admission hearing.
Last opportunity
No, of
was
course,
given,
one-
last,
yes.
yes.
Once
Yeah,
we frame the substantial question of law, there's no question of objecting it.
Yes, yes.
We'll have to argue on that.
Yes, argue on that.
Yes, your lord.
What is to be done?
Maybe issue may, the.
No, he wants to, he wants
No,
to
last,
consult
Yeah.
with his.
independently cannot, going on for
And-
adjournment. So
Heard Mr. M, but learned counsel for the petitioner.
Your lordship, one
And
submission,
also,
the agreement was already been made, and someone who is not a
and
party, how
also
can
heard Mr.
E Paying, your lordship?
Chipay, learned counsel for the respondent,
Yes, for respondent number 1,
1 and 2.
1 and 2.
1 and 2. That's all.
Yes.
Yes, your
1 and 2 only.
1 and 2.
yes.
Respondent number 1 and 2. After hearing the learned counsel for the parties, come on. The following substantial question of law are framed herein below. Number 1, whether the sale is executed only by the seller which is not registered can be a valid document or not. Number 2, not for also, whether the hearsay evidence without supporting any other circumstantial evidence can be relied upon. Can it be? 7 also.
Your lordship, only 3,
Your
only
Lordship.
3. The rest are all,
I think one of the important is that 4. Because there is a written agreement. Four and 8.
Next, whether there can be any conditional sale deed. Or whether there can be any conditional sale deed, if so, whether the such terms of the conditional sale deed is to be complied. In accordance with the, no. If so, whether such terms can be complied under the law. Then we'll use this. And whether evidence whether the learned trial court has refused to consider important evidence having direct bearing on the disputed issue. What is the last one? Whether refuses. No, whether the learned trial court has refused to consider the important evidence having direct bearing on the disputed issue. That's okay.
Yeah.
Only
And lower court record.
admit all for the trial court record. List the matter after 4 weeks.
Yes. Apply.
Much obliged.
I'll fine tune it. Let me just apply my mind. But only three issues will be. I mean the substantial question. Three. Yes.
Lots of the matters pertain to correction of date of
birth.
date of birth.
Is it permissible? What is recorded in your service book?
Lordship.
What is recorded in your service book? Which documents you are relying on for correction of the date of birth?
Yes, Lordship, there is a rule under
So that's why I'm asking
yes.
which documents you are relying on. That it is wrongly recorded or it ought to have been. On the basis of which documents?
For which, Lordship, I have submitted a series of representation.
Forget about it. I'm asking which documents you are relying.
My date of
Any
birth.
date of birth, I mean the birth certificate, school certificate, which one?
Birth certificate, Lordship.
Where it is?
Which is, Lordship, I am filing IA for that, Lordship.
Had Mr. B. Taipudia, learned counsel for the petitioner. No, not heard. Mr. B. Taipudia, learned counsel for the petitioner. Press for and is granted 3 weeks time. 3 weeks.
Lordship, on next Tuesday, Lordship, if possible. I am filing tomorrow only, Lordship.
A week's time to file additional affidavit.
Lordship.
Additional
IA,
affidavit.
IA, Lordship.
For what? IA for what?
For bringing record of the
That's
submission.
the additional affidavit.
Lordship.
Additional affidavit. Yes, sir.
Obliged, Lordship.
List after week.
My lord, service report is awaited to respondent number 2.
Mr. T. Tapolan, P. Tapolan, consult with the petitioners. And MSL Hagelan, additional PP for the state are present. They were service report. This
Right.
after 4 weeks.
Yes.
Lordship, we have
Yes.
filed one I last time, but some spelling is mistake. So Lordship,
Had Mr. T. Topo. T. Topo. Land consult for the petitioner and MS. L. Hagelan, additional PP for the state. Award service report. In respect of respondent number 2, list after 4 weeks.
Obliged.
Your Lordship, here as per direction of the last order, Lordship,
Yes.
we have the petition number 2 file affidavit
It is number 2.
to the complainant. Your Lordship, here the matter is the husband and wife. Sir.
No.
Complainants are wives, Your Lordship.
Okay.
So,
So we'll list for admission.
Your Lordship, matter may be this admission hearing.
Lordship.
What do you say?
Lordship, as per the last,
Have you received any?
no, no, Lordship.
The matter is, what is this?
Lordship, they have
Offense?
settlement, Lordship.
Yes, offense
Matter is just for causing the complainant.
498A.
Yes,
We'll ask for the call for the records and we'll
Yes.
dispose it on next day.
Yes.
All right.
yes.
Mr. T. Gyadi.
ठीक है,
T.
ठीक है.
T. Gyadi, land council for the. Not Mr. T. Gyadi, land council for the. And also MS El Hagelan, additional PP for this. Pursuant, as per the petitioner has filed, the petitioner, number 2, has filed the affidavit as directed to this court. As permitted by this court on 01/05/2024. Call for the, no private respondent,
No private.
call for the trial court record.
No, sir.
Scan copy of trial court
Copy.
record from
From the Lordship, CGM, SEPA, Lordship.
CGM SEPA. Learned CGM SEPA, huh? Learned Chief Judicial Magistrate, SEPA. List after 3 weeks.
Obliged, Lordship.
Your Lordship, service report is still awaited for respondent number 1, 2, and 3.
Service reports in respect of respondent number 1, 2, and 3 is awaited. List after 4 weeks.
Much obliged.
may I please, my lord?
Yes,
My lord, this is a joint application file for criminal causing of FIR and a charge sheet.
office note, Mr.
N. Rama.
N. Ramalan Council, heard Mr. N. Ramalan Council for the, and also El Hagelan additional people forest. Office note that is 04/06/2024 reflects that the trial court record is yet to be received. List of register to send reminder. List after 3 weeks.
Obliged.
Extremely sorry, Lordship. Lordship, in this case, whether I have to file additional affidavit in regards to the other petitions.
You file it.
Yes.
No, in the meantime,
There is 3
in the
petitions.
meantime, the land council for the petition is granted, is permitted to file affidavit in respect of
Two
petition
and
number,
three, additional appeal,
petition number 2 and 3.
2 and 3. Yes.
Must.
In your lordship, 2 occasions, the petitioner was remain absent and they have challenged the NBWA, your lordship. NBW, non-available warrant against the accused who were absconding in the case of NDPS case, your lordship, whose car was involved in the
So what is to
alleged
be
offense.
done?
Your lordship, since this is not a revision petition, the matter can be dismissed on default, your lordship.
Huh?
Since it is not a revision or appeal, it can be dismissed on default, your lordship. This is the 3rd time they are not appearing in this case. They are challenging the NBW, your lordship, non-bailable warrant against the arrest.
Non appears for the, can be.
It is not, your lordship, as far as Supreme Court judgment, only revision, criminal revision and
Non appears on call. Non appears for the petitioner on call. Mr. T. Attilan and the self-PP. For the state is present. Challenge made by of this revision petition is whatever is that?
non-bailable warrant.
Non-bailable warrant of arrest.
Yes, your lordship.
Where it is?
It is in Annexure 3, your lordship, page number 23.
Issued by the
Lordship, special NDPS court, your lordship.
NDPS.
Special judge NDPS.
NDPS. West Coming district. West Coming.
Yes, your lordship.
West Coming district. Bombdila. Against the petitioner.
And additionally, your lordship, one more submission. During the pendency, charge sheet has been filed, your lordship.
On next paragraph, on 2 consecutive occasions, the non has represented the petitioner. It is informed by the additional PP, Mr. T, that the charge is already been filed. In view of the petition is dismissed.
Yes,
for non-prosecution.
Yes.
Can I say?
Yes, your lordship.
Can I?
Your lordship, since it's not revision, they can restore it by invoking 482 itself, your lordship.
Is it correct?
Yes, your lordship. They are not on the merit of the case, your lordship. They are not on the merit of the, only for recalling the NBW, they have deeply obliged.
Non-prosecution, huh? Now, in view of the above writ petition, the civil criminal revision petition is dismissed.
Criminal petition, your lordship.
Revision petition.
Not revision, your lordship. Criminal petition.
It's a criminal petition.
Yes, your lordship. Under 482, not under 397. Revision is not permissible, your lordship. Revision and appeal.
Yeah. So, in view of the above, the criminal petition is dismissed.
Deeply obliged.
What is this?
If I may, Your Lordship, I would like to apprise Your Lordship to give a short date. I have yet to go thoroughly through this file.
Have you received the case diary?
No, not lordship.
Yet to receive.
To receive.
Not Mr.
K. Tana.
K.
Tana.
Tana, Land Council for the State, and also Ms. MS El Hage, Land Resistant People for the state. It is informed that the MS El Hage, Land Resistant People submits that she is yet to receive the scanned copy of the case diary. Let the matter be listed after 2 weeks so as to enable the learned PP to additional PP to
Much obliged.
obtain the scanned copy of the case diary.
Yes. Please after lordship.
2 weeks.
Please, lordship. Oblige, lordship.
Melody, CD was called for. my lord. Oh, sorry, sorry.
Record yet to be received.
My lord, this is joint application, my lord.
$498A.
Yes, my
Have
lord.
you, have you settled?
Yes, already settled, my lord.
What are you? Are you a husband and wife?
No, my
Husband
lord.
and wife.
Yes, my husband and however, my lord, we are living separately today.
It's, FIR is on page 22, Lordship.
Record is yet to be received. And Mr. M. Dozilan, counsel for the petitioners. And also MS El Hagelan, additional PP for the state. Office note dated 04/06/2024 reflects that the record is yet to be received.
In that case, my lord,
List after the registry to remind, registry is directed to issue reminder.
in that case, my lord,
After 2 weeks.
my interim prayer may be
Interim
considered.
order was earlier shall continue.
Last time, my
It has
lord,
not been
there was
passed
no
yet,
interim.
Lordship.
Huh?
It's not been passed yet, Lordship, interim.
Next prayer in that case, considering that the pending in the interim. No, pending production of the. We'll ask for a scan copy.
Lordship.
Trial court record, scan copy of the trial court record. The criminal proceedings
GR case number
of GR case number
180 of 2019.
180.
180. 2019.
No.
No, PS case number 42 2019 as well as
GR case
GR
number
case 180 2019.
180.
2019.
Where it is?
Lordship, in the page 2, Lordship.
Okay, GR case number 180 of 2019. Pending before the
CGM Alom.
Chief Judicial Magistrate, Alom. Shall remain state.
Obliged.
Obliged.
My lord, CD was called for, my lord, but my lord, without CD also, my lord, this matter is pertains to accident, my lord, which was caused by the brother of the petitioner number 1, my lord. He hit the truck of ITBP from behind, my lord. There's no question of rash and negligent when a person hits a vehicle from behind. So they have settled, the brother realized, the petitioner number 1 realized that it was mistake of his brother. So they made an agreement between them. Moreover, the petitioner number 2 is an army personnel, my lord. So because they may move anytime from one place to another. So in the name of that one, for sake of country, my lord, the petition number 1 has, my lord, they have settled the matter.
304A.
In many occasions, this court has interfered, your lordship.
Hmm?
In many occasions, this court has interfered, your lordship, when they enter into the settlement in 304A as well, your lordship.
You have no objection.
Your lordship, I will read out this statement first, your lordship, then the statement of the appellant rider, your lordship. On being examined, the witness said that in the month of December, on 9/12/2023, I and deceased person was returning from the Doimuk on a motorcycle bearing registration number so and so. The deceased person was riding the bike and I was sitting behind him. The deceased person was riding the motorcycle at a high speed despite my request to slow down. Therefore, on reaching at the Tigdo near ITBP camp, I saw one ITBP truck taking right turn to enter the main gate, in which the deceased person lost his control over the motorcycle, hit the truck from the behind, where I sustained minor injury and the deceased person was taken to the hospital by the ITBP personnel in their ambulance, where the EMO of the TRIMS declared him brought death, your lordship. So considering these facts and circumstances, your lordship, the incident also, and since they have entered into the agreement, enter into an settlement by the family member of the deceased, Your Lordship, I have no any objection, Your Lordship. Because in many occasions, Your Lordship, 304A has been quashed.
But Malad, in this mutable, while the vehicle was, Your Lordship might have seen the ITVP cam. The truck was coming from Doimuk side, and while it was entering the gate, Malad, while the vehicle was entering, turning towards the gate, the motorcycle came from behind and hit the vehicle, Malad. Therefore, the question of rash and negligent, Malad, the 304A causing death by negligence also wouldn't, Malad, make out in this case, Malad. And my brother has already read the statement, Malad. I don't think, Malad, if the matter, Malad, should be allowed to carry on, Malad.
Your Lordship, the only limited consideration would be the whether the family member has been properly compensated or not, Your Lordship.
Malad,
That aspect has to be looked into. Only that much, Your Lordship.
Malad, the brothers has accepted it was because he lost FIR because on emotional outburst because his brothers caused that. Later on, he realized that it was purely mistake of his brother.
No, have you compensated anything?
No, Malad, this is a driver, Malad, army personalist driver, Malad. How much money he will have to compensate, Malad?
Where was this agreement?
Malad, the Lordship will find it last page
17 anything.
My last paragraph in the first page, and whereas after proper inquiry, Lordship, it was found that it was the mistake of the deceased who was riding the bike in a rash and negligent manner without driving license and wearing helmet. Hence, the both parties have decided to resolve the issue amicably and according to the executed settlement deed. Now, the condition, first party expressed condolence for the loss suffered by the second party for the death of his brother due to the accident. The second party consented that he will not contest or pursue the above mentioned case any further as the accident was unintentional. Moreover, the complainant accepted that his late brother himself hit the ITVP truck from behind. Hence, the second party has no more grievance against the first party. That the first party is an army personnel having person serving for the nation. Therefore, further pursuance of this, the instant case would immensely affect on the service career of the first party. Hence, in the name of Allah, the second party has forgiven the first party for his better life. That the both parties agreed that instant settlement agreement is executed with a sound mind and without any force.
Heard Mr. P. Thapulan, counsel for the petitioner, and also heard Mr. T. at Leonard Edison BP for the state. This is an application under section 482 of CRPC Command 1973. Bring for enforcement of FIR being the new PS case number 78 of 2023 under section 279 304 within bracket capital A bracket clause 337 of IPC 1860 on the basis of the settlement between the parties. He just said joint petition, huh? This is the joint application. No, so and so, filed by so and so, jointly filed by the petitioner. The case of the case, the fact of the case is that on 09/12/2023 at around 4 to 5 p.m. one ITV feet truck bearing registration number CH01 G12240. Driven by Head Constable Sandeep Singh. Come on, petitioner number 2.
Yes.
Hearing was coming from the Pola camp side. Come on, while entering into main gate of ITBP camp at UP. Come on, a motorcycle bearing registration number AR01H. There's 5338. Come on, hit the truck from the behind. At a very high speed, and as a result of collision, come on, the rider of the bike, namely Azimul Haq, succumbed to his injuries, and the pillion rider Sri Licha Obi, come on, sustained minor injuries on his body. Mr. The FIR was lodged by the brother of the deceased, namely, this is Nazimul Haq, before the Dharmuk police station, which was registered as Dharmuk PS case number 78 of 2023 under section so and so. Next, madam. It is contended that the petitioner number 1 had filed the FIR out of emotional outburst and anger, as his beloved brother Najibul Haq.
Yes.
Najibul Haq had lost his precious life due to the accident. Later, the petitioner number 2 came to know that the fault was on the part of his late brother, as he was riding the motorcycle at a very high speed without driving license and helmet. The petitioner number 1 has forgiven the petitioner number 2 and agreed to resolve the matter amicably and executed an agreement between them on 13/05/2024. It is contended that the petitioner has no grievances against the petitioner number 1.
Against 2, man.
Petitioner number 2. In that case, petitioner number 2. Next paragraph. It is further submitted, contended that the petition number 2 is a military personnel who is serving the nation. Therefore, if the present case is allowed to proceed further, it would cause immense prejudice on the service of the petitioner number 2. On having realized, then next paragraph, the petitioners, it's okay. The parties have jointly pressed for washing of the above the PS case on the basis of the agreement as well as the facts narrated of herein above. Yes. Next para. Mr. T. At the learned additional PP. Where is that? What is that? Case diary.
Yes, sir, your lordship, may also reply
Referring to
the statement of the, your lordship,
statement of the,
Licha Obi, your lordship, pillion rider. Yes,
while referring to the statement of the pillion rider.
Yes, your
Sri
Licha Obi,
Licha
OBI.
Obi.
Yes.
Come on. What is your submission?
That the deceased was riding the bike, your lordship,
Submits that
at high speed, your
in
lordship.
fact the deceased was riding the bike on a high speed and
Without wearing helmet.
without wearing helmet, and hit the truck behind the hit
Lose his control and hit the truck.
and lost his control and hit behind the hit the truck
From the behind.
from behind.
And your lordship, one last one, your lordship, the postmortem report also says that the cause of death was of intracranial hemorrhage associated with fracture skull bone resulting from blunt injury of the head, accidental in nature. PM report also says.
The postmortem report also indicates that the cause of death is accidental in nature.
Yes, your lordship.
Accidental in nature. Having submitted above, Mr. T at the London Additional PP fairly submits that the FR may be caused by invoking the inherent power of this court. Next matter. Consider the submissions of learned consequently. This application, next para, is noted above, is for quashing of the FR, which was registered as Dormant PS case number 78.
Yes, your lord. DMKPS case number 7823.
78 of 2023 under section so and so so and so. The informant, complainant or informant? Complainant.
Informant also.
Informant.
Yes,
Informant brother.
The petitioner number 1 here in comma. Is after proper inquiry found that it was mistake of his deceased brother who was riding the bike in a rash and negligent manner without driving license and wearing helmet. The informant had filed the FIR in a moment of emotional outburst, anger and distress due to sudden death of his brother in the accident. Next paragraph. It is noted that the petition number 2, who was driving the ITBP truck, is a, what is army or what?
Army one.
Army.
ITBP is also army.
Huh?
Yes.
Paramilitary.
Paramilitary force.
Yes,
Paramilitary.
Who is serving the nation. Mr. Records also reveals that records reveals that the petitioner was, the deceased brother of the petitioner number 1 had hit the was riding the bike in a rash and negligent manner without driving license and wearing helmet, and hit the truck driven by the petitioner number 2 from behind. The next para. Petitioners have entered into a deed of settlement on 13/05/2024 by settling the matter considering the facts involved in the considering the facts of the accident as well as the petitioner, the respondent number being paramilitary force is a paramilitary force personnel who is serving for the nation. In the case of so and so, we'll just refer to that. We'll not say, we'll say that has been Madhya Pradesh versus so and so.
Lakshmi Narayan.
Lakshmi Narayan. I find that it has been included everything.
Yes, Your Lordship.
After considering all those Narendra.
Yes, everything. Gyan Singh, Narendra Singh, everything.
There are 15, huh?
There are 15, yes, Your Lordship.
15.1 to 5, huh? Having considered the matter in its entirety, come on. No. In the present case, as noted above, the records reveals that the record reveals that no fault can be attributed to the petitioner number 2, as it clearly indicated that the brother of the respondent, deceased brother of the respondent, petitioner number 1, was driving the bike without driving license and wearing helmet. First of the cause of the postmortem reports also indicates the cause of death as accidental in nature.
Yes, Your Lordship.
The petitioner number 1, number 2 is a parliamentary force personnel who is serving the nation. The parties have already entered into a settlement on the basis of the facts related herein above. And they have forgiven the petitioner number 2. No, not forgiven. Settlement. Restore. Having considered above, I am of the considered view. No, and we consider the methods in attempting. This court is of the view that the continuance of investigation of the Police case number 78 of 2020 under section shall not serve any purpose as the petitioners have entered into an agreement on the basis of the facts narrated here in above. Accordingly, this court finds that this is one of the cases with the inherent power of this court under section 482 of CRPC 1970 would be invoked for washing the FIR. Accordingly, the FIR so and so is hereby washed. Petition allowed. And this one.
Obliged, Your Lordship. Yeah,
Over. Yes, call is ready. Huh? It's not ready.
We have it.
Call after 10 minutes. Yes.
Case number 4, there is the FIR. Something of the FIR that the officer injured comment Mr. Secretary, District of Rachel Valley, subject FIR and respected Madam, respectively on dated 0305 at 7:16 p.m. I received a call from police personnel SI Rosni saying comment Mr. Secretary and informed that they have rescued 3 minor girls in this Jumla Rosni, age 8 years, this Kamki Taye, age 10 years, and this Jan Kuni, age 16 years. When conducting prosecutions with the arrested 2 persons, Mr. Jamla.
Just wait. Sessions Court, the record, the name of that other person has been recorded to be involved. Not you.
Not you.
But then your bail has been rejected.
Yes, because of that.
That has to be looked into because
Then why you are not challenging that?
yes, that's it.
Including the bar under the law. If it is no, if it is clear, we cannot help it.
Yes.
Though I may be with you.
You have to come across that
First
hurdle,
thing
Your
is-
Lordship. Then court will hear on
You
merit.
think about it. First, you have to implead them. Whether maintainability and all will decide.
Yes.
Then I think you have to challenge that order of rejection of the sessions.